Welcome you all to the lecture series on corporate law. The lecture series aim to address the legal community, particularly students of law, who are eager to learn the nuances of corporate law with the intention to introduce the subject to the people who have no access to understand, learn, and explore the latest developments, and also learning from the people who have the exposure of this subject for a period of more than 2 decades. I introduced this subject with an intention that the young lawyers and the students maybe avail the benefit out of my experiences and also learn the subject in a lucid way. And the present video is an introductory video, very brief video. Just I will try to introduce the subject. In further lectures, depending upon the feedback and interactions, we will try to move on the subject over a amount of 40 to 50 lectures on the same subjects, which I would be uploading one by one after recording the lectures. And the present subject, which I have titled, is the corporate law, and some places the subject is also used the nomenclature of company law in LLB curriculum. The subject of company law is a compulsory paper in the LLB curriculum as mandated by the Bar Council of India. We do have a lot of literature available in the form of the textbooks as well as the various other online lectures. My intention of this lecture is that, or this introduction of the subject, to motivate the young minds, to motivate the young legal minds, sharing of my thoughts on the experiences which I had over a period of time in the legal academia or as academicians. Now let us start discussion that why do we study the company, or what is the basic purpose for introduction of the companies in company law? What are the benefits which we see, or how this company as a legal person, which gives either advantages or the disadvantages as compared to the other legal, the other legal entities. Say for example, majority of you may be aware that we have the partnership firm, society, association of persons, and the family businesses. We have the business in the nature of unorganized sectors, the law which avails, or the law which provides various guidelines how to conduct a particular activity. Now let us talk about specifically the terminology of the company which gives certain facilities or certain advantages. The first and foremost important is that once we incorporate a company under the Companies Act 2013, it says that it acquires a separate legal personality as different from the members who incorporate the companies. When we see the text of law, you can create a legal personality and the company for the purpose that is a lawful purpose. This is where which we see the text of law under section 3 of the Companies Act. The Companies Act never speaks that you are commencing a business or any lawful activity only for the sake of profit. Yes, it is understood that every business and majority of activities, the byproduct of the activity comes as the profit. When there are profits, the profits are being divided as a matter of dividends and it is distributed among the shareholders. Now let us see this separate legal personality in the sense the members who created the company becomes a separate after the incorporations. So the purpose and the point is that the people who incorporate, there are two natural persons who incorporate a private company, they become separate as compared to the partnerships. In the case of the partnership, what happens? There is this individual liabilities. Individual liability in the sense, if two people starts partnership and the two people who are there in the partnership, they becomes individually liable. Like otherwise, there are other type of legal personalities which are created in the later part of the law, particularly LLPs. There is another legal entity, and do we have the legal mechanism or a personality created by virtue of law, and this personality is running in the eyes of law, and this personality is going to die in the eyes of law. That means a company is created in the eyes of law and the same company is going to get death in the eyes of law. And the people who created the company, they become a separate personality. That is one of the primary the primary concept of the company. Along with that, the other one is called perpetual succession. That means the members who commences the company, even if they die, even if they are not existing after the incorporation of the company, this company is going to exist in the absence of the members who promoted and who created the company. Because in the language of the business, we call the promoters. The people who are responsible for the creation of the company as the promoters, there is a common language. Though law talks about the various characteristics for the promoters, how the promoters will come into existence and the liability and all. But if we say in a simple language, promoter is the one who is responsible for the creation of the companies. So once you have a promoter who created the companies and these people are separate from the company, because that is what comes as a two distinctive identities. One identity is the individuals. Second identity is the people who created the company itself. Now let us move on to the another important concept. Once you incorporate a company, the fundamental doubt will come that who is the owner of the company and how the company runs and how it becomes different from the natural persons. So the very fundamental difference of the company is that according to the Companies Act, company is the owner of the companies. That means on the date of incorporation of company gets its own identity. Company tries to acquire its own properties. And this is which we can see in the very jurisprudential perspective, that is called the existence of ownership and the legal personality in the eyes of fiction of law, otherwise called as the fictional theory of law. The real companies are the individuals who runs the business, but when you look about the practice of the law and the text of the law which regulates the legal personality, that is corporations, it is individuals who are the whole responsible for certain activities and their function. However, in the eyes of law, it is more shown as the what we can say the corporations. So the two important concepts, one is the separate legal personality, then it can have its ownership, and having another concept is the perpetual succession. Though these some of the concepts will come as a characteristics of the company, I try to introduce to you that the advantages of having a company doing a particular activity. Now let me go back to the same slide. We have another concept, companies which are created for the charity. And this is the new development of Companies Act 2013. If you refer to the section 8 of the Act, it talks about charity. Not only the charity, there is other concept called as social welfare. So we can have a company even for the purposes of the social welfare. So if I want to remove inequality in society, I want to establish a social welfare society, I can have a company under section 8. Then company law permits the individuals to establish a company for the purpose of social welfare, and therefore you can start the company and you can raise the capitals. And the fourth point is that incorporation, the fees. This is what we are going to read in the next slides. And the next slide, it is basically talks about how many people are necessary to start the companies. So this is very simple. How many natural persons are required? It's called the how many people require minimum to start the companies as incorporations. If you see the text of corporate law, it says that the minimum number of people for the private limited company are 2. This is the minimum, and maximum it goes 200 members. So we have the minimum 2 and maximum 7. When it comes to the public limited company, in the public limited company we require minimum 7 and maximum it is unlimited or it is being prescribed. It is not prescribed in the text how many maximum that they can go as far as the number of members are concerned. It varies from the share capital, otherwise called as the unlimited. And whereas in the case of the one person company you can have the 1. Since it is a private limited company, we can assume the maximum is 200. Now in the same slide, here I made it another point, that is minimum numbers. When you look about the public limited company, like the natural persons and the legal persons. Some of you can have a doubt. What is this natural persons and what is this legal person? Say for example, A, B, C, the individual's natural person. Take for example, A limited, B limited, and the C limited, and the D limited. And total you are having here the 4, here the 3. That means 3 plus 4 is equal to 7. The 7 persons, in the 7 persons, these 4, that's called the corporations, like the companies. This we call it as the legal persons, otherwise called as the artificial person. So you have created artificial person in the eyes of law, and we have the natural persons. Why 3 is necessary? Because the Companies Act provides 3 is necessary because in public limited company, the minimum directors are 3. So therefore they brought in logic that you require 3 natural persons to have the company for incorporation. Now, the underlying principle is that the companies can be incorporated by the corporations. The majority also can be companies. That means a legal person can also create another legal person. And in a brief, the total number of people which you require for the private limited is the 2, for the public limited is the 7, for the purpose of one person company, it is the 1. So this is the minimum number which you require to start the company. Now once you are identify the members, that you have the 2 people, then you require how to start the company. You have the 2 people are there. Now how much money you require to start the company on the day 1? Say for example, today, which is the second, say that 5th October 2022. If the 2 A and B wishes to start a private limited company, and they are having with them, say for example, 50,000 rupees in pocket. Can they incorporate a company? A and B, who are having 50,000 rupees in their pocket, can they incorporate? After having certain minimum documents with them, because company law provides, like for any of the legal process or incorporations, even if you take it, if you want to open a bank account, you require to have the Aadhaar card or permanent account, or they called unique identity number. So if we look about the corporations, the members who are going to be created, or the members who are going to create the company, they are supposed to get in one certain identifications from the government of India, that is direct identification number, and some declarations from the lawyer. So you have certain procedural aspects which is majorly taken care by the secretarial assistants. That means the two people who have some money, they can approach either the company secretary or the chartered accountant or some other people who are doing, maybe lawyer, who are doing the process of incorporations. But these people and these individuals, end of the day, the important concept is that what is the capital you require, otherwise called what is the money you require. On today's world, there is an application called Spice++ application, which is available in the Ministry of Corporate Affairs. Because when you are reading corporate law, everyone requires to keep updates on this particular website because of this digital era and digital innovations. The access to the information, the access to understanding of the subject is given elaborately or is provided in these particular public domains. So in this application which says up to the 15 lakh rupees of the capital, you don't require to pay any fee. Then you can have the companies for a specific purposes, like for example, startups, ease of doing our business. Because now the startups becoming very, very prominent in this era. So when you want to have a small startups and you have 1 lakh rupees or 2 lakh rupees with you, and you can start your company, then you can go for raising of the capital through the banks or through fund managers or other people. The point which I want to explain is that in the today's world, up to 15 lakh rupees of the capital, you don't require to pay any of the stamp duty as per the today's developmental laws, as for today the applicability of the law which is provided by the ministry guidelines for ease of doing our business and for the startups. And however, these are the special classification of companies. The other example is that, coming back to the simple here only, when you talk about these people like which were having the 50,000 rupees, they can have a small private limited company by paying up the stamp duties. What is this stamp duty altogether? The stamp duty is being paid when members who are incorporating company are creating the capital which is authorized by the MOA and otherwise called as the artificial capital. So you want a particular amount of money to do a business. So you are bringing that capital into the markets. When you are bringing that capital into the market, then you are supposed to pay a stamp duty which is prescribed under the Indian Stamp Act. Therefore, depending upon your authorized capital, you are supposed to pay some quantum of amount. Then it determines and it changes from the amount which you are bringing. Now the point here is that the capital is determined by the promoters or the members who are responsible for the incorporation of companies, depending upon the nature of their activities and depending upon the nature of their business. It is not very straightforward formula which is given to the business wise as far as company is concerned. It is given to the wisdom of the businessman. It is given to the wisdom of the promoters. it is given to the people who are incorporated in the company how much capital they want to bring and how much they can able to pay the stamp duties. Otherwise, what will happen is that if I start saying that you don't require to pay stamp duty for each and every activity, then there will be a mushroom of companies in India. When you have the mushroom of companies or the growth of companies, and it will create the havoc. So each and every transaction which has a law, or each and every transaction which is being regulated by the law, it has some implications on payment of the tax. And that tax which we are talking here is the stamp duties. And for the future updates on a particularly in the development of this incorporation of companies, kindly keep it in the mind the application based of incorporation of company and the application based what we call it as the Spice plus plus and the Spice. It is an app created by the Government of India for the creation of companies. Then there are two documents which are necessary for incorporation of company. Those are MOA and AOA. We will see those documents in the very soon in the next lectures. And these documents basically try to talk. One is about the MOA and other one is the Articles of Association. When you look about the MOA and Articles of Association, then the incorporation of company, the primary document is the Memorandum of Association. It has certain important clauses. Because when you start the company, you have to first identify importantly what should be the name of the company, where you are going to incorporate, then how much objects what you are having, then you are having with regard to the capital, then you have the liabilities. It is as simple as that. When you want to start the company, you have to identify the name. But these things we can discuss in the furtherance of the classes. I just want to introduce the subject, and as introductory lecture, I try to inform you, the people who are listening out of this lecture, because this is my, I can say, a debut attempt or a first attempt in online lectures. I will try to record as many lectures as possible. Then I will try to introduce the subject by the module wise. This I taught an interpretative or the introductory way, how the people can receive the subject on corporate law, and in particularly the nuances of law, reading of law from the text, from the legal perspectives. Because when you look at the corporate law has various dimensions. One is lawyer's perspective, other one is company secretary perspective, other one is chartered accountant perspective, other one is manager's perspectives. Now majorly I try to put it how the legal aspects are there in the subjects. Because I belong to the law field and there is a lot of depth to have an access a subject on up-to-date manner. So I thought let me use of this particular lectures series which I initiated this year, that is 2022 October. I will try to record a series of lectures. I will upload one by one. The people who have interest and the people who are really want to learn the subject in participatory approach, in the participatory way, all are welcome to listen my lectures. And here I am pausing my lecture and not stopping. So I am pause the lecture because it's not a stop means an end. So we will have the another lecture which will comes about the MOA, that is Memorandum of Association. That means what is the document which you require? That's the first document to incorporate the companies. So we will discuss in the lecture number 2 which is dedicated for the document which is required in order to incorporate a company, and what can be there in the document we will discuss in the next class. The present lecture is only aimed to understand why the company, that's what I'm just giving the brief. So why the company? Because I try to explain it has a separate legal personality and different from the natural persons. Liability from the natural person to the corporate personality. And section 3 of the act also talks with regard to the lawful purposes. That is what the section 3. It's very important, as everybody thinks companies are created for the purposes of the profit. Yes, there is no dispute on that. However, there is something beyond that. That is, companies are created for a lawful activity. You can have corporation for charity. You can have corporation for protection of environment and the social welfare. These are now codified in the text. Then I moved on how many people are necessary, either the 2, 7 and 1. Then moving further, how much capital you require, that is the money. And I also tried to put it a SPICE++ application, where in the SPICE++ application you can find out sitting in one place, using of technology and the mobile apps, you try to develop this, or you try to incorporate the companies, because this is now important. The technology made, or the technology is making all of us to understand the nuances of the subject, to understand the law, because the technology driven society we are having today, because technology brought the developments, say for example, application based and technology, which we can say the digital era and the digital technology, so making us ease of doing a business, ease of access. If we say that I don't follow the technology, yes, nobody dispute on that, it is our individual discretion. However, I will not sustain in the market, because we should be techno savvy in this technological era. So the next class we will be talking about the documents need for incorporation, MOA and AOA. I will try to discuss that one. And thank you all for patiently listening my lecture, and thank you.